Right, thank you so much. So the previous panel that we had emphasised the importance and the role of openness in data and transparency in data in promoting trust in new decision-making processes, and also emphasised how better information about how the system operates at the aggregate level can help to build confidence. This panel takes a slightly different perspective on this issue, so it's exploring the way in which citizens' experiences of new processes can promote or actually undermine public trust and confidence in new decision-making processes. We have an absolutely stellar panel. Again, all their biographies are in the programme, and they're mostly far too long for me to possibly read out without boring you and running over time. But we'd like to start by introducing Professor Tom Tyler from Yale Law School to talk about this issue. So thank you very much, Tom.
Well, I want to thank Hazel and Natalie for inviting me to come and speak to you. I think it's amazing to see what's going on here. In the United States, we worked for decades to try to get the courts to even consider changing at all. And here the question is it too much? Which is really quite a refreshing and different way to look at the problem. Okay, so we all have a fairly abstract view of why we have traditionally had the courts, which is the idea that societies need to have some forum that people can go to for the redress of grievances, to get justice. And what we're talking about here in the most fundamental way is, what do those forums need to look like? Do they need to be public forums? Can they be private forums? And whether they're public or private, what sort of framework is required? And one question is, what are the different ways we could try to address these questions? So I'm going to be explicitly focused on the people. That is, the people who use courts and the people in the public, which, being a psychologist, I call subjective evaluations. So it's people's attitudes, people's values, people's behavior resulting from those. And we can think of a whole bunch of questions that we would want to ask about different forums and different ways of managing grievances. We would ask, when do people feel that fairness occurred, that they receive fairness? This is not just some abstract question because it bleeds into these other more central actions people take, like, do people accept and abide by decisions? Do they follow the law in the future? Are they recidivists and you have constant disputes, or do they follow rules that have been decided on? Does the handling of a dispute have positive social consequences? Bind up wounds, continued relationships can go on, and maybe most broadly, how does it impact on people's views about the judicial system and government? We've traditionally had a view, certainly true in the United States, that the right way to do this is to have a particular kind of public forum. That public forum is a physical courthouse with a judge. We've been hearing a lot today. We heard some, and yesterday, a whole day on this, about what we see as being the virtues of that traditional model, a variety of virtues, like decisions based upon law, an opportunity for public values to be injected into private ordering. All of these things can be true of public forums, and there are reasons we traditionally wanted to have them. But I think it's really important not to conclude, certainly from the point of view of users, that change from this model, this traditional model, is necessarily a bad thing. And what I think we need to really talk about, and the theme of this meeting, is what kind of evidence should we collect to evaluate these changes in relationship to the traditional model. We have a whole variety of potential constituents. We have the people in the dispute. We have the people who watch the dispute, their families, their friends, the people in their neighborhood, and we have the general public, who are all potential groups impacted by what they think is true about our judicial system. All right. Now, when we talk about change, I think it's first important to acknowledge that this traditional model in many ways is already changing, and the many ways in which it's changing have been laid out during this meeting. We've talked about diversion away from courts, ADR, mediation. We've talked about the rise of online dispute resolution as an alternative to traditional courts. We've talked in the United States a lot about the limit of class action, so we're restricting access. We have the growth in the kind of private agreements that Judith was mentioning that restrict access to traditional courts. And one thing that we heard about this morning that I think is a very important development in the United States is the decline in individualized, personalized justice, where more and more decisions are being made by algorithms, whether it's a prediction of future risk in a criminal case, whether it's an appropriate settlement in a civil case. So there is no individual decision maker in the system. It's being done based upon some kind of a computer algorithm or system of assessment. So there's a lot of change already going on. And many of these changes are reflected in the innovations that we've been talking about during this conference, and we've seen many of these already talked about, moving away from people being in a physical courtroom, the way people interact with the judge. In the descriptions about this reform, the written descriptions, there's much more emphasis also on algorithms, and until this morning we haven't talked much about that, but these are all changes that reflect changes that have been going on in court systems everywhere, and certainly in the United States. What drives these changes? We've heard arguments about people want lower costs, they want ease of use so they can have access, they don't want delays. I think the big question from the point of view of someone who's studying users and the user experience is, are those really the issues that drive the way people react to their experiences in court? Are these concepts of greater access through lower costs, faster dispute resolution, are they going to be important in two different ways? Whether people will accept the decisions that are made, resolve disputes in ways that are productive and continuing, and how will people react to the forum in terms of the government forum or the private forum? How will it impact views about government and society? All right. Well, let me start at the simplest level, which is talking about the involved parties, and then move to a broader discussion about the population that is reacting to what they think is true about the courts. So when we talk about the immediate parties, one of the things that we're very concerned about is acceptance of judicial decisions, and why would people accept and abide by them. My own work with the courts began in America, working with judges. Primary concern, people wouldn't obey decisions. They would go into court, get a decision, the judge hands it to them, says obey it, and they just walk out and throw it away. And this was a quite serious problem. So the question is, couldn't we find a way to promote people wanting, or at least being willing, to accept judicial decisions? I'm going to give an example of a study. This is a retrospective study. It's people talking about their experiences in court once they've had them. And it talks about a large sample of people in two major California communities, Oakland and Los Angeles. And as is typical, most of the experiences people have with the law are with the police, but I'm just going to focus on the experiences people had going to court. If you went to court, what would determine how you felt about your experience? We can think of three different models. One is what I would call the folk model, which is people just want to win. If you ask people, and we've heard some of the comments to this effect yesterday, they say, I just want to win. I want to win. I'm right, I want to win. So you might say that's what determines how you react. You might be a little bit more sophisticated and you say, I don't want to win, I want the right thing to happen. I want people to get what they deserve. And then you might say instead, what I'm really concerned about is that there is a fair procedure, a fair process involved in this situation. So decisions are made fairly, I get treated fairly. It's not so much about the outcome as the procedure. Well, what do people care about? We can test that by interviewing people and asking them about these different aspects of how their case was resolved and looking at their reaction. Like, did they voluntarily accept the decision? Did they appeal? Did they fight against it? Are they angry? And we can ask, what determines deference or acceptance of judicial authority? If we look at this, these heights reflect the importance of each of these factors in acceptance of decisions among the three major demographic groups in America: whites, African Americans, and Hispanics. And the key point here is that for all of those groups, the overwhelming factor that shapes whether they do or don't accept a decision is if they think they got fair treatment. This is true for people who go to court because they have a dispute or a complaint that they want resolved, or they're required to come to court, a criminal court. They're brought in by the state. And it's true not just for deference to the decisions, but also, do you trust the judge? So broadly, people care about procedural fairness. And that is now the key research finding for many studies. When people are reacting to dispute resolution, criminal law forums, they care about if they think it was fair. And that's much more important to them than whether they win or lose, or how much they win or lose. This supports a long history in jurisprudence of talking about due process of law, emphasizing due process of law. Why do judges wear wigs? Ours don't, but yours do. But the point is to create a sense of legitimacy and fairness. And that's very consistent with what people want. But we also know subjectively much more about what it means to a person to say, I want fair procedure. And I'll outline the four things that constantly come up in people's evaluations. Two are about decision-making, two are about treatment. Decision-making, voice. Do they have an opportunity to present their evidence, state their case to the decision maker before decisions get made? Perceived neutrality. Is there evidence that the decision maker is being unbiased, factual, making decisions consistent with the law? Fairness of treatment. Do they feel that they are treated with dignity, courtesy, respect, as the members of a community who are entitled to come before a court and receive serious consideration? And do they think that the authority they're dealing with is trustworthy? That is that person listening and considering the parties' issues? Are they trying to do what's right for the parties in this situation? Are they sincere, benevolent in their intentions? Those four factors always dominate people's reaction to not just a judicial procedure, but really any similar type of procedure. Let me just illustrate the value of voice using a prospective study. This is a decision about what kind of procedure would you like to have to resolve a dispute. Here, this comes out of the work in the United States about Obamacare, about healthcare decisions. How would you like decisions about your healthcare to be made? Two procedures. One, you have voice, you talk to the doctors, you discuss and participate in how you're going to be treated. The other, decisions are made by medical professionals and basically you're treated. How much would voice be worth to you? So if you're told that you can have the high voice procedure but it costs more, how much would you be willing to pay? People, 90% of people will pay $3,000 extra to have voice. And you can see eventually when you get to about $20,000 more for voice, people are indifferent to having or not having voice. People say that they would pay a lot of extra money to have a procedure that gives them voice. Similar question, if on average people live longer, if they let doctors make the decisions and they stay out of it, people still prefer to have voice in the decision, even if they're told that they're on average going to live 5 years less long if they make their own decisions as opposed to letting a doctor make a decision. Finally, when you get up to 20 years difference, people say, well, we better let the doctors do it. The point is, that people value these procedural features and they're willing to give things up to keep them, like money, like life. And this is the important thing about a subjective reaction to a procedure, is it's about elements that people really care about that make them feel that they've had their day in court, that they're being fairly treated. Retrospectively, there are many other studies. I don't have time to go through all of them, but they're like the study I showed you from California. They show in a variety of different civil settings. People want voice, they want explanation, they want hearings, and they will endure costs. They will push forward with appeals that make no economic sense to get those things. So the question for us is, what kind of forums are going to provide people with this experience of fairness, with this idea of I had my day in court, I got a fair procedure. And it's first important just to realize that you can't trade that off by saying cheaper, faster, because that's not what people are really concerned about. From an empirical point of view, I think the point I would make, consistent with what Dawn and other people have been saying, is we can actually study how particular procedures fit into this. Prospectively, like the study of healthcare, which would you choose? Retrospectively, after you've had the experience, did you think it was fair? Will you accept the decision? How do you feel about the courts? Okay, all right. We can also broaden this question, and I think it's important to recognize that legitimacy is an issue here. It's not just about the private parties, it's about the legitimacy of government, the legitimacy of the courts. So what promotes legitimacy? Here I'm going to use another study, Overall Trust in the Courts. This is a study of the people in California. What aspects of their views about judges lead them to say they trust the courts? Do they make decisions fairly? Are they honest and follow the law? Do they treat people fairly? They listen to people, they treat them with respect, they care about their needs. Why would you say that the courts are legitimate? Or is it substantive justice? The judges follow the law. Our performance, they make decisions in a timely and inexpensive way. Oops. Okay. All right. So in California, among people who've been to court and haven't been to court, you can see that the dominant reason for trusting the court is that judges treat people fairly. They care about their needs, they listen to them, they try to do what's right for them. Less concern about decision making, but certainly a concern, and then very little concern about performance. So performance is not really central to public trust in the courts. It's whether the judges are responsive. It's also true of studies of the general United States that pit fairness against these performance issues of cost and delay, and studies that pit fairness against substantive justice. Okay, and this is not just about America. So there's a really interesting study of, of attitudes about the court system in the UK and the EU. I gather they're different now, I'm not sure, but okay. Okay, what do people care about? What do they say concerns them about the judicial system? Perceptions of fairness and due process. Feeling that judges are out of touch with people in the community, they don't care about their needs, they're not interested in doing what's right for them. Exactly the same issues I already talked about. And what don't they care much about? It's the efficient functioning of the courts. So this is not just an American thing. This is something that we see also in Europe. All right. So the key point to me is that across all these different forms of dispute management, conflict resolution, there's a very common theme. Whether you are a person who actually went to one of these forums because you had a dispute, or you're just a member of the community who's looking at what you perceive to be the operation of this institution, do you have confidence in it? Do you trust it? Do you accept its decisions? See it as legitimate? It's about this concept of fairness. And interestingly, that concept is enshrined in substantive law, but it's also enshrined in the minds of the people who live in our communities. The final thing I'll say is, hopefully, we would talk about the need for both prospective and retrospective research on different forums. When we do that, one of the things about the structure of process that the same research shows is it's not necessarily the structure that matters. So, for example, in America, informal procedures such as mediation are viewed as very fair by many users. And formal procedures like trials are often viewed as unfair. So it's not the forum per se, it's what's going on within that forum. And so what we need to look at is how do all kinds of different variations in the structure within which a process unfolds affect how people experience that process. For example, internet communication with a judge. It may be that it's not that it's email that's a problem, but if there's no sign of responsiveness on the part of the judge or awareness of people's problem, could be that if a judge shows personalized concern about a person and their dispute, that email communication would be fine. The point is that we ought to be looking at the experience of fairness and trying to understand how the nature of the forum impacts on the experience of justice, knowing that all of these outcomes, decision acceptance, solving the dispute in a good way, having confidence in the system, are coming out of the sense that a fair procedure was used and not out of either I won the case or I didn't pay much to go to court or it happened quickly. Those kind of instrumental evaluations are not as central. Thank you.
Thank you so much, Tom. That was great. Yeah, thank you. Thank you so much, and that was so interesting. And one question I'd really like to hold for later is whether there's been any study about how unfair an outcome people are willing to accept through a procedure that they perceive as substantively fair, subjectively fair. And this broader question of how fairness maps to our notions of legality. And it was really nice to see in your presentation the role of courts, raising the role of courts as appliers of the substantive law to the facts of case. And I wondered in the slide where you were thinking about how ordinary people assessed court, that's one of the ways in which courts build legitimacy. But given what we know about low levels of public understanding of the law, how well equipped are people in general to make those kind of decisions about how well a court's performing in relation to substantive law, and what more information do people need to be able to make that? But I'd like to introduce now EZSettle, who's come to talk to us. We've been super excited to hear her presentation, so please go ahead.
Hi everyone, and thank you Hazel for inviting me. So it's great to be talking after Tom, because he set the stage for a lot of what I'm going to talk about today, which is how resolving disputes online affects user experiences, and specifically in court settings. And building on what Tom has said, we know that online dispute resolution procedures and online court procedures have traditionally been justified primarily on necessity grounds, the volume of disputes, the caseload that courts are facing, the time that it takes, and also on accessibility, the way that we can provide better physical access to the procedures and process designs that are intended for self-represented litigants. But when we use this framework, we are not necessarily attending to the concerns about the quality of the procedures and the way that the participants in those procedures, and particularly self-represented litigants or litigants in person, experience this move to an online process. And we can ask what kind of influence conducting a process online has on both the substantive outcome of the process and the procedural experiences or procedural justice experiences that users have in court. And that's what I would like to talk about today. So when we're talking about online dispute resolution procedures and even online court procedures, as we've seen in the presentations yesterday, we cannot talk about a homogeneous, unified concept of online processes. We have a multitude of technologies and process designs that are being used, and each one of them may affect users differently. And as I said earlier, we should assess both user experiences and their behavior, and they're not necessarily correlated. So when we're talking about this umbrella term of online processes, generally we're talking about a process in which users complete the full dispute resolution process on an online platform, from filing through final determination, although we know that in practice we have many hybrid processes that involve both online and offline procedures, and that oftentimes we would have a tiered model that includes several technologies. And in this rich spectrum, we have different court settings, so we may have family courts and tribunals and civil courts, and different dispute types of different complexities, value, and subject matter, and different dispute resolution methods, technologies, and process design. And each of these attributes work together in creating different effects, or they may work together to affect differently the way users experience and behave on these processes. So really the challenge for researchers is to, and also for policymakers or system designers, is to unpack those different attributes and to try and study or understand how they interact in affecting users' experiences. So we may have different user experiences on the same technology depending on whether the process is a diagnostic process or an intake process for a procedure, whether it's a consensual negotiation or a mediation process where the parties are still the one to determine the final outcome, or whether this is a binding, decisive process such as arbitration or a judicial process. And we may also have different user experiences depending on whether the technology or the online interface is used merely as a communication platform or also as a technology that does more than that, generate resolution options, calculate trade-offs, or even determine the case. And so the question of agency and the role of the technology in the process is very important. In either way, we have to acknowledge, as Larry Lessig so aptly put it, that code is law, and the technology is not neutral. The way that the technology is designed affects the way that users use it in ways that are oftentimes not obvious and not immediately apparent. And this concept has been recognized in the early days of ODR. Ethan Katz and Janet Rifkin have written already in 2000 about the fourth party. Technology as another party that is influencing the process in the same way that the litigants or the disputants and the third party neutral influence it. So just as a quick overview, we can talk about different types of involvement of the technology in the process, different effects on the process design. Mere transposition, so we're basically conducting the exact same process, but we're doing it online via video conferencing or an email. We can talk about restructuring, which is a big piece of the improving access to justice or making processes accessible to self-represented litigants, where we're reorganizing the process, we're simplifying it, we're breaking it into different steps. We're also maybe offering tailored legal advice as we go about the process. And we can talk about really novel processes that leverage artificial intelligence, deep learning to generate new results, learning systems that provide parties with statistical outcomes that are not necessarily based on the information that they themselves provided, and also things that are beyond the scope of this talk, such as different social models, leveraging social networks, reputation, crowdsourcing in the resolution of disputes. This is sort of more of a private sector approach to dispute resolution. And in reality, we see mostly hybrid processes that combine in different tiers of the process gradually these different types of technologies. So now the question is, how do specific online process design affect users? Specific meaning the dispute resolution method, the type of technology and the role that it plays in the process, and the context, what kind of legal proceeding we're facing. Users, primarily self-represented litigants, we have to admit, but possibly also lawyers, and we've heard Susan yesterday talk about testing with lawyers and users, and the effect on both the procedural experiences and the behavior, the kind of choices that litigants are making as they go through an online process. So we can talk about choice architecture and the way that the interface design and the way that the legal choices and steps are presented affect the actual actions, the legal actions that parties are taking. So we have very little research on how this is actually working in legal context and particularly in court context, but we do have other frameworks and data that we can build on. So the procedural justice literature is very informative for this kind of research. And we also have a lot of research conducted in other settings, from education through health decision-making, even negotiation, on the effect of conducting interaction online and on interacting with technology, interacting with software. How do people respond to a software counterpart in other contexts? And the literature on, we should say, digital choice architecture, which combines both UX, UI insights on how to affect or manipulate users' behavior on digital platforms, and general behavioral economics or judgment and decision-making or barriers to conflict resolution, whichever strand, wherever the social psychologist is working, on the effect of heuristics and biases on the way that people make decisions. So how can we test these things? We have different possible methodologies, starting from basic, simple online experiments where we would present a hypothetical and ask people to respond to it. We have the approach that I'm going to present today of immersive experiments, conducting or creating mock online platforms and then varying or manipulating different elements in order to measure how it affects parties' behavior. Hopefully, I hope in the future, those of you here in the audience who are actually designing and managing online court platforms or other ODR platforms, A/B tests that are controlled, where we are actually looking at the way actual users respond to changes in the design of the process. And of course, we do have the possibility to take data, if we get access to it, from multiple online dispute resolution service providers, both private and public. I just put a few here. There are many more, and I wish we would have the chance to get some of this data to actually look in retrospect how changes affected behavior on the system. And if there's internal information also on surveys on how users perceived it, that's great. So what did I do and the work that I'm presenting here today? I basically collaborated with computer scientists in the CHIME lab at Stanford. So this is Communication Between Humans and Interactive Media lab at the Department of Communication, to build mock ODR platforms and then manipulates elements in the process and measure how it affects user experiences. So they filled a post-experimental questionnaire on their procedural justice experiences, and then we could evaluate the effect. And the instrument was, of course, adapted based on this research that was done in offline settings to an online environment. I should emphasize already now, there is a big limitation on these studies as we think about public reforms in the court system. The subjects were very tech-savvy Stanford undergraduate students. In some instances, this actually strengthens some of the findings. In other ways, they undermine them. So a grain of salt and a word of caution as we look at the results. So I'm not going to spend time on this slide because Tom did such a wonderful job in talking about the procedural justice indicator. But I'm just going to emphasize we're talking about the procedural fairness of the process, the way decisions are being made, and the input that users can have in that process, but also the way that they are treated, which could be very sensitive to online communication and to communication with a non-human, two things that I'm going to talk about. And also, what kind of experiences users are having emotionally, how does this affect them, their satisfaction and their sense of empowerment as they go through the process. So the first experiment is an online experiment that was looking at asynchronous judicial procedures. This was done in an experimental setting at Stanford, so I chose the judicial process that exists there, which is an honor code violation with the Stanford Office of Judicial Affairs. And what I varied was the medium of communication used by the student who was charged with the violation and the judicial officer, so the university professor who is in charge of determining the case. And the question was, do the experiences of the student subjects vary depending on the medium of communication used by both the judicial officer and the student, with the idea that we may not want to use the same medium of communication for the two parties. So we've seen here yesterday that we're mainly talking about either video or text hearing, but we may want to talk about combinations of different technologies depending on how users react to them. So textual online platforms are really the baseline for ODR. The vast majority of ODR platforms around the world are text-based in different levels of leanness or richness. So some of them are forms, some of them are free text or combinations. It's less costly, it's easier, it's accessible to many people. And I will argue that there are also some advantages for self-represented litigants in using a text interface because research in other areas has found that this is useful for conflictual or ambiguous tasks. It counters some power imbalances in interaction, and it allows them to focus on the content when there's a challenge in processing that content and countering some of the effects that have been observed in courts with self-represented litigants in brick and mortar courts, where they're basically shushed. They're unable to make a legal account, but rather a relational account, and so they end up not being able to have voice or to participate in courts. On the other hand, video communication, and there's a lot of research on the richness of the medium, is believed to be the closest means of communication, if we discount now virtual reality and very advanced immersive environments, to face-to-face interaction. And there are big gains also in terms of procedural justice, in terms of the treatment, the sense of being heard, being respected, having empathy, true interest, as Tom has mentioned earlier. But it's also more costly, and the infrastructure demands for conducting fully online video hearings for a large quantity of cases could be prohibitive. And so basically what I tested was different combinations of text and video communication, so either two-way text, two-way video, or varying the judge and the self-represented litigants on text and video. So this is what the interface looked like. It had the full visual language of Stanford websites at the time. And then we had a text editor and a video player and video capturing technology. And basically what I found was that it does make sense to combine technologies in the sense that self-represented litigants did find the textual interface more supportive, or in some instances there was no procedural justice gain in moving to video communication, but it was important for them to see the judge and to have some interaction, video interaction with the judge. I remind you that this is an asynchronous process. So it's not real interaction, but they actually get to see the face of who's making the decision and hear what they're saying. The text was completely standardized. Everything was scripted, so there were no variations in content or the timing of the delivery of the message and so forth. And this was a very intensive experiment. It spanned over 3 to 5 days because there were some exchanges at the different stages of the process to mimic a true judicial affairs case at the university. The whole cover of the experiment was that they were testing a real system. Students were very invested. We got a lot of feedback. It's too bad that the Office of Judicial Affairs was not considering this as a true change. And here are some of the results. So greater voice for the self-represented litigants, right? So a sense that they could express their view, present their side of the story, even though what was changing was what the judge's medium of communication. They felt that the process was more fair, and interestingly, they felt that it improved interactional justice, so the judge's attentiveness, respectfulness, trustworthiness, and now no similar gain moving from to SRL's video communication. Importantly, we can see that using text was also conducing to reducing the anxiety that the litigants felt as they were going through the process. Okay, I'm going to use my few last minutes to present some results of another experiment, which was looking at a more advanced and relevant question, I think, to the future of diagnostic processes and guided negotiation and mediation on online courts, which is comparing the role of technology as either a communication platform that is operated by a human third party or a completely automated platform. So these are the algorithms that we were talking about earlier, the ability to construct these decision trees that promote the negotiation automatically, or in more advanced technologies, and looking at their interaction with the decision control. So the method of dispute resolution. Does it matter whether the technology plays a facilitative role or a decisive binding role in determining the dispute? So who decides the final outcome? And for that, I constructed another platform. It's called EZSettle. It mimicked a combination of existing at the time online dispute resolution services in the e-commerce industry. This is also important for that context. And it was quite elaborate as a process. And this was a synchronous process, so it happened live. I'll skip over some of the details just to show you a little bit what this included. So we had a full priming on who are the third-party neutrals who are involved in the dispute. Everything was entirely identical. I don't have a clicker here, but you see it was the mediator is typing versus the system is generating text. But other than that, everything was entirely similar. They had to indicate both numerically and with words their proposals and their offers in resolving the dispute. So this was really a full process. And what I found was quite interesting, and I showed you this interface also so you could put it in context, that this was a very lean interaction. It really relied on short snippets of text and a lot of numerical input. So that's an important context for some of the findings. But there was a preference, a very overwhelming across all measure preference for the software mediator over the human mediator. But that preference did not transcend once the software made the decision. Even though there was a very basic arbitration process, it was clear that there was a preference on some measures to the human arbitrator. So here is how it looked like. With the software mediator, the process was deemed more fair. There was greater sense of participation for the parties. They had less negative emotions when they interacted with software. We can attribute that, at least in part, to their expectations as they interact on such a platform that is very limited in terms of their interaction. And they felt that the mediator was more effective, which is interesting because, of course, the performance was completely standardized. Interestingly, users felt that they had more voice, that they were better able to express their views when it came to the human arbitrator as opposed to the software arbitrator, and quite a large difference there. And they felt that the outcome was better explained, although, again, everything was completely standardized. So there is something human in our sense of the way that we appreciate justice and what we think about the concept of justice as we go about the decision-making process. Interestingly, the human arbitrator was also seen as more respectful. And I'll stop with the findings here and just say that I think some of the takeaways here are, first of all, that we need to be mindful about what is the specific role that the technology plays in the process. I think that we need to be mindful of what improving procedural justice can contribute to us, and I just will refer you to Tom's presentation. And I want to talk about the justifications for relying on automation and AI, and this is relevant for the first tier of the online courts and to other systems, because it may not be as bad, and it may actually be helpful for the users to have that kind of systems because of what we know about power imbalances, what they feel when they interact with other figures of authority, the legal system as a whole. So there may be justifications for this, not just on the grounds of efficiency, but also on the grounds of improving the quality of the experiences for the users, and maybe using that actually realize the vision of tailoring the form to the FAS and creating different process designs in these early stages, because through technology and software that is actually financially feasible. And I don't have time to talk about choice architecture, but we'll keep that for the coffee break. So.
Thank you, Hazel, for inviting me and putting this wonderful conference together, and also putting me on a panel with fascinating research, and I hope I'll be able to add to that. And I think ideally I'm going to try to bring together a few different strands that have come up so far in the conference. So fairness and justice, which is talked about a little bit recently. Data access, which I think is something that a lot of us care a great deal about. Randomized control trials, about which I will present one, and I'm sure you're going to hear more later. And algorithms, which we've heard come up a number of times. I'm going to present preliminary findings, more an outline of a study that uses an algorithm. So this is actually a real-world algorithm that is currently in place in a justice system today, and so I'm hoping that might be able to focus the discussion a little bit that we're having, sometimes in the abstract. I'll give you a real specific example to think about. So thinking about the citizen experience of justice, so this is clearly something that is changing. We already see that it's changing here in the UK, and is going to continue to change with online services coming on, and increased access to data and algorithms is going to also be a very important piece of that change. And so I want to talk about how I think algorithms can be used not wholly for evil, but maybe for good as well. So I'm going to start with a movie that some of you may have seen. You'll remember this one. This was Tom Cruise in his heyday in Minority Report. And this is a film where crime in the near future, crime has been virtually eliminated, thanks in large part to three sort of supernatural creatures who live in a swimming pool. Those are them. And so we might think about, how far off are we actually from this? And by the way, this is not a wholly optimistic view of the future, because it raises trade-offs involved with reducing crime to near nothing, in that Tom Cruise's job is to stop people before they've actually committed crimes. So it raises, I think, some very important kind of philosophical and questions about justice. So we don't have to have the swimming pool, it turns out. We're getting closer and closer, and we'll increasingly get better at being able to predict crime, not necessarily at the moment on an individual basis like they do in the movie, but certainly in aggregate. And the question is, how do we use that? Can we use this in good and productive ways? And is this going to undermine some of our notions of fairness and justice? Spoiler, I think we can use it for good. I don't think it needs to undermine the way we think about the judicial system, and I think it can be used in conjunction with attorneys and judges and people who think carefully about fairness. So computerized algorithms, they're here. They already have immense impact on what we read, who we socialize with, what we buy. I think they have tremendous potential to improve our judicial system. And again, this is going beyond what a lot of the focus yesterday on getting our courts online. That makes huge sense, getting access to data. This is going to help feed into the next stage, which is taking that data and using it to improve the justice system. Not that getting the data and giving access isn't important. It's extremely important in itself. This is kind of the next step. How can we modify it? So algorithms are nothing new. They've been used certainly for decades and really centuries to try to think through who might, especially in the criminal justice system, who might we be most worried about incarcerating, even if we use checklists today or rating scores. Those are examples of algorithms that have been used for a long time. So I'm going to describe a project over the next few minutes called Better Bargaining, where we're using a new type of algorithm, machine learning, a couple machine learning algorithms to see if we can use it to decrease sentencing disparities. And I said I'm going to speak to fairness and justice because I think one area that I hope is non-controversial about something that at least I view as fairness and justice is when similarly situated people get similar outcomes. And that is a big problem in a lot of justice systems, that there's a lot of randomness to them. People's outcomes in the justice system vary depending on where they live, precisely what crimes they're charged with, which is up to the whims often of a local prosecutor or a policeman, what color their skin is, what attorney they get, what judge they get. So this project is aimed at looking at one of those sources of unwarranted disparity. It's based on the attorney. And so I'll give you a quick intro into the setting where we're running this experiment. So many of you have probably been to Las Vegas. Fun place, but sometimes people get a little bit carried away and things go wrong. You go out with your colleagues for a nice civil dinner and then you end up in a bar fight later. This is my colleague Jonathan Click. He's really not that violent. Can't speak for myself. All right, so what happens when that goes on in Vegas? All right, next thing you know, the police have taken you away in handcuffs, put you in jail to sober up, and then an arraignment and bail setting. So after that, hopefully you're let out, but you're facing charges and you can't afford to hire your own attorney on a poor academic salary. So as an indigent defendant, I'm faced with a public defender who I don't get to pick. In Las Vegas, and you rarely get to pick as an indigent defendant, in Las Vegas in particular, they use random assignment of their attorneys to clients, which is something that an aspect that I've used in the past to study, to learn about legal representation. So that's what's going to happen. And the problem is, what I learned from previous work is that which attorney you get, and it's not going to be a surprise to anyone in this room, which attorney you get matters immensely and impacts your outcome and, frankly, potentially the rest of your life to a big degree. You get a good attorney, you might get off with a fine. You get a bad attorney, you might be spending several years in prison. Hopefully not just for public drunkenness, but if it got carried away. And so the thought here is, what if we could introduce something, a new tool, a new algorithm made available to the attorneys to give them, to try to level that playing field a little bit across the attorneys. And this is a little mock-up of it. I'm going to go into a little bit more about precisely what we did. Could that decrease this randomness coming just from which attorney you get? So previous work I alluded to was also a study done in Las Vegas because of their random assignment of attorneys, and found substantial variation in outcomes based on which attorney you get. Really substantial. So if you shift from, you rank attorneys in order of ability, in this case a defense attorney is pretty clearly supposed to minimize their client's sentence. If you rank them in order, you take the person on this part of the line and you instead get this part who's a good attorney, and instead you get the person in this part of the line who's a bad attorney. you could expect to increase your sentence by 82% of the mean. So it's a big, big magnitude. And again, this is only one of the pieces of sources of disparity in the criminal justice system. One thing we found in that study was that, maybe also not a surprise, more experienced attorneys had better client outcomes, and especially through plea bargains. And so from that came a hypothesis that some of this difference is probably due to more accurate predictions about likely outcomes of cases. And so this leads to this idea for an intervention. What if we could level the playing field? What if we could basically simulate a wise senior attorney who can advise the new public defenders, or maybe the less talented public defenders, on what similar cases look like? Unfortunately, no public defender office has the resources to have something like this, so what we're trying to do is simulate that wise advisor. And in so doing, we're going to ask a few questions. So primarily, does the provision of greater information to public defenders and their clients reduce disparities in sentencing? It's the main impact. And then it could also have ancillary outcomes and ancillary impacts on recidivism, on time to resolution, on attorney time and cost, and putting my psychologist hat on even on satisfaction with the process. More broadly, so this is a first attempt at studying machine learning in a judicial context, or even in a professional context. Can we use machine learning to provide experts with recommendations that can improve their performance and consistency? So again, this is not replacing attorneys with algorithms, it's augmenting attorneys with algorithms. And ultimately, it's always up to the attorney still to advise their client. So here's the intervention. So we have trained a machine learning algorithm using historical data. The algorithm predicts the sentence length and the likelihood of incarceration. And the access to the software is randomly assigned to public defenders. A random assignment is extremely important if we want to learn clearly about the efficacy of something. I think you're probably going to hear more about this in the final panel today, but I just want to emphasize that this is key to being able to evaluate the efficacy of this intervention, is doing it in a real-world setting and doing it in such a way that we can tell the only difference between the individual's performances, the attorney performances, is who got access to the predictions and who did not, and that's randomly assigned. We're focusing on public defenders because they tend to have larger office sizes and greater independence, and a fair amount of variation. So this is where we're starting, but the plan is that this could be used not just for public defenders, but also potentially for judges and prosecutors. But this is where we are beginning. So this is this is a screenshot that can be accessed on a website, through your computer, through a phone, through a tablet, and it's got a list of the attorneys' pending cases with case numbers, statutes, descriptions, a little bit of information to make sure that they're picking the right one. They click on one of those, and this pops up, and it's got more detail on the case, just for two reasons. One, the attorneys find this helpful because they don't have this summarized anywhere else at the moment. And two, just to make sure if they do know something about the case that we don't, that we include all information that is currently available. We ask them in some of the cases to predict what they think the fraction would be incarcerated and what the most likely sentence is. This is for the experiment to see whether, one, how accurate their predictions are, and two, whether those who have the furthest off predictions are the ones who will gain the most from access to this. And they don't always get these questions. And then they get our algorithms predictions. And so they'll give both these two main numbers, kind of the likelihood that the individual will be incarcerated and the most likely sentence. Sometimes we have a range, sometimes we have individual numbers, and then we've got this precision meter color-coded to indicate confidence in our predictions. So this is a measure of the uncertainty in our predictions. If our predictions are too uncertain, we will not give them at all. So we have a threshold below which we will not give a prediction if the case is something that we can't predict very well. So that's the intervention. Let me now, and I'll say this, we have a pilot of this currently running in Las Vegas, and the full experiment is launching this summer throughout their office. I want to just talk for a minute, though, about machine learning, which is in use in this experiment, and just talk a bit about it and its pluses and minuses. So machine learning, it's basically just learning from data, algorithms that can recognize patterns without explicit programming. Compared to currently standard econometric techniques, they're just optimized for out-of-sample prediction, not necessarily for causal inference, though. So the advantages are that they're better at prediction, have flexible functional form, and are very good, especially when you have extensive data sets with a lot of variables. In this case, we have about 10 years worth of historical data from the court, which is good, but not great. So we have about 100,000 historical cases. Google has terabytes, trillions and trillions of data points when they use machine learning, and that's where it's really powerful. And so one of the questions I had going into this is whether machine learning is actually worth it and what it adds. Because we want to help predict the sentences based on what information is available at the moment. And this has already been mentioned, that machine learning is something like a black box. And is it worth it, this algorithmic complexity? Do we gain enough to make it worthwhile to go into this black box? So I'll just present two figures that show a little bit about how machine learning is helping here. So this is a distribution of the errors between, this is using historical data. So we made predictions on historical cases that have already been adjudicated using our algorithm. This one, we made the prediction several different ways, and we took the difference between the prediction and the actual case outcome. So what is plotted here is a histogram of those deltas. So if you got it right on, then you'd be right at 0, and if you got 12 months too high, you'd be up here or more. We truncate it here. So there are a lot of outliers that are beyond 12 months off. And then we plotted this using a few different techniques. So blue OLS, that's just standard regressions that have been used for many years in many applications. Red is ridge. It's a modification of a standard regression. That's, let's say, baby machine learning. It's not even really machine learning. It's a little bit of an improvement. And we can see from the red line that it shrinks the errors a little bit. So going from OLS to ridge improves things. And then on the next slide, I'll show you how random forest, which is one of the machine learning algorithms that we use, improves things. So again, here's blue is OLS. It shows how wide the errors are. And going from there to the machine learning algorithm improves it a reasonable amount. Now, the question then is not for me, but kind of for you, for everyone, is that enough? Is that enough to justify the reduced transparency? And there's a whole kind of aside and discussion about whether we can use machine learning to come up with algorithms that are close, a little bit more transparent, that have almost as much power, but not quite as much power. Let me raise one other concern besides the black box, reinforcing existing biases. So this is a cartoon to illustrate kind of current sensitivity and discussion of the impact of race, especially in stop and frisk policing in the U.S. It's just a few weeks ago in Philadelphia, a couple African Americans got detained and arrested by police for hanging out in a Starbucks not too far from where I live. This is an ongoing issue. And the concern is if race has historically been influential in ways we think is unjustified in sentencing, if we're using historical data to make predictions about future sentences, aren't we just going to reinforce existing biases? So there's been a lot of discussion about this and writing about this in recent years, especially in the last couple of years, a lot among theoretical computer scientists who are working on this. I want to make a couple points very quickly. So one is that the application matters. And I would argue that our application here, which is providing information to defense attorneys, is one where we're not as concerned about it, because the goal of the defense attorney is to make the best argument they can for their client using the best data available. Now, if we're thinking about providing this to prosecutors, judges, parole boards, and others, they're going to have to grapple with this issue. And I'm just going to summarize this quickly and say, one way to look at this is as a constrained optimization problem. There is a trade-off. If you want fairness in whatever dimension you want, if you want unbiasedness, if you want to take race out of it, and race is predictive, you will get worse predictions, but that might be worth it. And that's the correct way to think about it. And again, there's no correct answer. There's how to think about it. I'm going to, in the interest of time, leave randomized trials for Jim and Michael to talk about in their panel. And just to say, and just close by saying that machine learning is starting to be applied to a whole host of areas in the law, and I think it's going to increase. And as I'm happy that we're talking about this here today, and I think it's something that has a lot of potential to improve the access to justice.
Thank you so much, David. And I guess one point is, if you're using historical data to predict as a tool for defense attorneys to negotiate deals, then we're sort of assuming that the prejudices of judges hold steady over the past 10 years, right? Because, it's sort of a bit depressing because it's like... But yeah, anyway, questions from the floor. Sorry, Michael.
A simple question for David and Jim. I know also does a lot of this actual real-world randomized work. What type of IRB
a rigorous one, a rigorous and vigorous one. But I will say this: so in this case, so it's human subjects. So that's kind of a standard piece of the IRB, as opposed to just using retrospective data, which tends to be easier. And but in this case, because some of the subject, so we're providing the recommendations to attorneys, but they can, if they choose, share them with their clients. So there was concern from the IRB that there might be defendants and potentially prisoners who were part of this experiment, and so that raised it to the next level of scrutiny. So we had a specialist within the IRB focused on kind of making sure there aren't abuses of prisoners. So it was an exacting process. There are now kind of these national reforms to IRB, which I think are going to make a lot of experiments in the social sciences easier and quicker to get approval for. But I'll say I thought this one was it was rigorous, but it wasn't it wasn't an impossible hurdle to get over, and it made us. It actually helped us think a lot about some of the aspects of the design.
I have questions for this fantastic panel. Questions for all three of you. In the interest of time, David, if you were a criminal defendant, would you care more about the fact that my sentence or my conviction probability might vary a lot based on the attorney that I have, or would you care more about minimizing the overall probability that I get convicted in the sentence? Because the way you presented it, I presume you're going to look at both.
Yeah.
I'm just curious, the way you chose to present it, I think, if I understood correctly, most about, in terms of reducing the variation among the different defense attorneys. And if I'm a criminal defendant, maybe what I say is, okay, look, what I really care about, I know I'm, especially in Las Vegas, based on prior work, I know I'm going to get a random draw, right?
Yeah.
And there are reasons for that. You know, you're leaving your prior work, you said recruiting, that they can recruit better if they don't just give all the new attorneys all the granular level cases. I'm just curious about why choose to emphasize that as opposed to the overall, probably, because it's easy, you can look at both. Yeah, we will. So the reason I emphasize that is because I think it's politically neutral. And really, and in thinking about justice and fairness, it is very hard to argue against people in similar circumstances getting similar outcomes. There are people who think sentences are too long. There are people who think sentences are too short. So this is more as a matter of salesmanship, I'll say, or presentation, why I focus on that piece of it than the level.
Julia and then Peter, thank you. It's really a comment on Jim's paper, but it's really an example in answer to Natalie's question about where on the continuum the outcome would be in relation to how people thought judges were fair. And you didn't use the word transparent, but it was about trusting judges. And an example came to mind from a study that we did when I was in Oakland, Oxford, which was actually looking at right at the end of the continuum where children were being removed from parents because of maltreatment. So this was in child protection litigation. And we interviewed parents at the end of the proceedings. And most of these parents, who were from a wide range of black and minority ethnic populations, including some asylum-seeking families, wide cultural, religious and language differences, but most of those parents said that they felt heard and understood and that the process was fair. So that's one end of the continuum.
Yeah, another question about procedural justice. I mean, it's quite a general term, I was thinking. This is the question to Tom here, looking at those kind of differences in your scores. It's quite a general term. I'm just wondering whether it's actually quite close to how people are actually defining the process. So what you're asking people is, when you actually ask this question, you're asking them to sort of define the process of some kind of judicial decision. It's a bit like kind of asking a teacher, or like asking about teaching, is information kind of conveyed in that kind of process? I mean, wouldn't it make more sense to kind of assume that some kind of notion of procedural justice is part of the conception of the process, but it might actually vary about the kind of procedural justice. So on a scale of procedural justice, would it matter if it's slightly harsh? So in some ways you might find less strong results on that point if you actually more precisely defined that notion of kind of justice to more closely to exactly how people are observing different moving parts of the decision.
Well, let me put it this way. As a psychologist, what I'm really interested in is the way that the experience is organized by the person who's having it. And these different categories that I talked about come out of interviews that identify different aspects of the process and look to see if people react to them, if they matter to them. And it, first of all, is true that people don't always think the same things are important depending on what the nature of the case is. But in general, we find people come up with these 4 principles that I talked about, and those are generally important to them. And so in that sense, it's a statement about how people are organizing their own experience. And to me, the crucial issue is a sort of behavioral consequence when they make decisions like whether to accept what the judge did or whether to follow the order or so on and so forth. These are the things that affect what they do. But I do think, and this is something Isla can talk about, that this whole new world that we're talking about gives us vast opportunities to look at all these different forms that we haven't seen before and what it is within those forms that people think is important.
Yeah, I want to add before I go to the online world that we also have studies that I think are probably 40 years of procedural justice empirical research that's been done, maybe even more And these same ideas are replicated across different processes, different cultures, different settings, different research methods, so in experimental studies and natural experiments and observations and interviews. And so I think there's quite a lot of confidence in these organizing concepts, regardless of the way the process is designed at the end of the day. And as for the way that this plays in online proceedings, I think that actually system design and process design is going to play a key role, because essentially, and this perhaps brings the piece about choice architecture, when we're doing this in constrained online interface, we're basically creating a choice environment, and we're influencing every step of the process, and we're controlling every step of the process. So that may allow us also the ability to control for some of these things that you're concerned about and find out more. And again, this would require, I think, in order to have the external validity and legitimacy of the findings, do that on an actual platform and actually experiment with what yields better experiences and also less biased behavior on the part of participants.
I'd like to try and marry a whole number of presentations together. I was really fascinated by everything you said, all of you. We know we have an issue in the justice system of bias, but different judges decide things in different ways. The more data we have in the system, the more obvious this will be to Joe Public. Lawyers all know it depends on your law, it depends on your court, which judge, etc. But it becomes obvious to Joe Public when it becomes very clear. And I'm thinking of the civil justice area and the family justice area much more than crime, which I've worked in ever. When I interview, I do quant work, but when I interview judges as well to get their understanding, they talk very, very strongly, I think we showed it to judges here, about their constitutional position of independence. If you give an algorithm to, or you try and inform the judiciary by an algorithm and say, try and get rid of your biases, this is really what we need to take account of. Well, you can have a judge or you can have an algorithm. One won't be biased and the other one will be. But bias might be in your favour or it might be against you. When I put these sorts of issues in a much more simple way to judges, they really say it's so constitutionally important for me to be independent. I don't want to touch any of this stuff. So we have a big breakthrough to make. Either we shelve the judiciary because they are so biased, or we retain them and we have to tame them to get rid of some of these biases. Because although I accept, and I think your work, Tom, is fantastic, procedural justice really is really important. Actually, people are concerned about the outcome, and in family proceedings, the outcome is not just the outcome of the adult parties, it's the outcome to the child. And we can show huge differences of outcome to the adult child according to different decision. And that I find really troubling as a child's rights person.
Can I just ask a quick follow-up to that? Yeah. Independent of what? Judges are supposed to be independent of what?
Fairness is independent. Well, everybody should have the same treatment before the court.
Right.
And the differences in outcomes are such that it's very difficult to establish. It would be very difficult to convince the public that actually they are getting the same treatment. And there's a great deal of difference between having a few months extra here on your sentence and having your child taken away or not.
So I can just make one comment about outcome.
Yeah, go ahead.
Okay, so I think it's important when you say people care about outcome to frame that, because it's related to Natalie's question about a negative decision. What we find is not that people are happy if they get a negative outcome. The question is, do they accept it? And they accept it if they believe it's arrived at through these fair procedures. think anybody is happy if they lose their case, but do they understand that there's a court and it used a procedure and that procedure was fair, so therefore they should go along with the decision, yes, that's what we find.
But there are some decisions where party compliance is much more of a big issue. So if you're fined, do you pay the fine? If your damages are against you, do you pay the... If I've already removed your child and we're just talking about whether you get effectively whether you get your child back, actually compliance doesn't come into it because the decision has already been self-executed. So a lot of these things, take them out of standard civil justice, take them out of standard criminal justice, the issues do get reconfigured a little bit.
If I could also interject, and I think also connect this to some of Judith's point about open court and accountability, and what we gain also by requiring a certain process to happen and having a record of how it happened, and how that reflects on trust in the judiciary. And also particularly on the point on family cases, because I think it touches on a very sensitive it's a very sensitive area, but it's interesting to see that actually online applications in family settings have had great success, and it's actually one of the fields where we see more private providers working, and also some research story, maybe can tell us a little bit about it in the Netherlands and Belgium, that shows that on the parties' side, we may be able to provide the decision maker more accurate information by using the technology. So it's not necessarily constraining the judge's power, but actually providing the judge with information that is less biased, because we're taking care of some power imbalances or the different ways in which men and women present information in such settings. And so there are different ways of thinking about it. It's not necessarily constraining judicial discretion.
Those sorts of processes tend to be around money claims, or they tend to be around children's time claims.
Both. So it would be both.
In terms of child provision, in terms of child provision, in any of it's a court issue as well as a privatised issue, that children are not generally parties to this process at all. Children are receiving, they're done to, they're not done with.
I'm Martha Cover. I'm a childcare barrister, so I've come out of the black box for a couple of days to join you here. And it can be quite dark in there, but I wouldn't describe it as a black box. And I'd like to say something about the suggestion that we need a significant correction to judicial bias in child protection proceedings, having practiced in that field and specialized in it for over 20 years. The infinite variety of cases that come before judges are, in my view, impossible to quantify in any way that would be helpful, although the patterns appear again and again, the patterns of domestic violence and of substance abuse and of mental illness and of learning disability and the horrible combinations of all of those things for the child and for the judge. And there is, in my experience and those of my colleagues in the Association of Lawyers for Children, no true problem of bias, real bias in the family judiciary in this country. And if there have been cases that have been conducted in a way which suggests bias, the Court of Appeal has been very robust in dealing with those rogue judges, if I can call them that. And so I think that the huge difficulty in trying, I think what the judges are probably saying is that they're very afraid of having categories of cases prescribed for them. This type of case should be dealt with in this way, Judge, because of the infinite kaleidoscope of each unique family case that comes in front of you.
Thank you. Well, I think we're going to have to draw it to a close there because it's time for lunch. I guess what I'd like to follow, and one thing that I've been trying to reconcile what we heard yesterday with what we heard today, and the Civil Resolution Tribunal in British Columbia, and what we're proposing in England, Wales, they're all designed around citizen experience, and they're working really hard to hold themselves to account to frameworks that are based on procedural fairness, so does it feel just? And that makes complete sense, but public justice systems are backed by the state, and their primary role is to enforce or apply the law to individual cases. Citizens, fundamentally, we know, thanks to Nigel's research, thanks to Hazel, thanks to Alexi, that citizens aren't equipped to determine the legality of outcomes. So it's not really a surprise that this doesn't factor into their assessments of the fairness of procedures, but I think what Tom's presentation raised is that there is something there that in order for courts to be perceived as legitimate, they have to demonstrate that they're making decisions in accordance with the laws as they stand. So is it incumbent then on the government or the judges to rigorously police the ability of these processes, to uphold the ability of these processes to deliver substantive justice, and then provide that information to the public in order that the public retains confidence in the legitimacy of new procedures? I wondered if that was something we might take up in the panel after the break.
Simple answer has to be yes.
Thank you. Excellent. Thank you.